Morning and welcome to JuryBall, putting the big data revolution to work in your cases. I'm delighted to introduce our speaker, Sean Claggett. Sean Claggett is the founder and lead trial lawyer at Claggett & Sykes law firm. Since opening its doors in 2005, Sean has grown the firm into a nationally recognized trial practice with offices in Nevada, Connecticut, and New York. Under his leadership, Claggett & Sykes has built a reputation for achieving record-setting results in complex litigation, earning the respect of both clients and peers across the country. Widely regarded as one of the leading litigators in the nation, Sean continues to set the standard for trial excellence while mentoring the next generation of attorneys. And now, let's get started.
Thank you for having me. All right. Well, we're going to talk about JuryBall today. And JuryBall, for those of you who aren't familiar with it, is the use of big data in litigation. And so big data, we'll talk about it today, is a little bit of an introduction, but I've been doing focus groups for the better part of the last 15 years. I've done over 800 live focus groups. And in the process of doing all those live focus groups, I started to realize that there were patterns. And being a math guy, when I saw the patterns, I thought to myself, geez, why are we seeing patterns with random people's responses to information? Well, it must be because human behavior is predictable. And so I started using big data about 12 years ago. And then about 10 years ago, John Campbell and I and Alicia Campbell met and we became dear friends. And we figured out John and Alicia were doing big data and their data was very, very accurate. And I began being a little bit of a guinea pig, doing a bunch of trials, relying on their data. And we kept getting very great results, predictable results. And so from the last basically 10 years, I've been running big data on all my cases, which is probably a reason why you see the large verdicts that our firm continues to get on a pretty regular basis, because we're choosing the right cases and we're getting the results that are consistent with the data. So let's go ahead and get started with the PowerPoint. So let me go ahead and share my screen. All right. So before we get started, the first slide we're going to show here is a very important thing to me, and that is to understand why you do what you do. You know, obviously I'm a plaintiff lawyer. I understand most of us as plaintiff lawyers are taking cases where we don't get paid unless we win. We're funding them out of our own pocket. So if we lose, there's a direct impact to us financially. But at the end of the day, we're helping people. We're giving people access to justice, and we're giving them access to the courtroom. As a defense lawyer, I don't know. That's something each of you would have to look at and say, why do you do what you do? What's the purpose behind that? But I want to have a clip on this because it's really important, because whether you're on the plaintiff side or defense side, what we do is hard. It's emotionally hard. You know, if you're representing the last case I just did, I was representing 11-year-old child who was run over and killed in a crosswalk. And it's brutal, right? You're talking to the mom and dad and the siblings and friends, and everybody's just still heartbroken about this poor little child being killed. And it's not just hard on the plaintiff lawyer. I mean, my opposing counsel it was hard on him too, because he's human. And we talked about it. We actually sat down during trial because we had a really rough day of testimony, and the two of us just sat there and we both cried. And so, there's the human element of what we do. But when you know your purpose, I think it makes our jobs more meaningful. So here we go.
How do I know? A lot of people, when they think of the phrase, how do I know, they always want to put the what behind it. How do I know what I'm supposed to do? The question that you really should ask is, how do I know why I'm here? Because when you know your why, your what becomes more clear and more impactful. If you know, like for instance, people know that I do comedy, but that's what I do. My why is to inspire people to walk in purpose. So I can do comedy, I can write books, I can be in a movie, because all of it is motivated by my why. In fact, I have a new web series out called Michael Jr. Break Time. We probably just did the 6th episode. It's on YouTube. So every single Wednesday at 3 o'clock, we drop a new episode on YouTube of Michael Jr. Break Time. What it is it's me. I travel around the country and I do stand-up comedy, in case you didn't know. And in the middle of my comedy set sometime, I'll stop and just talk to my audience. And we've been filming this, and it's pretty cool. So we're in Winston-Salem. I'm going to show you a clip from Winston-Salem. And I'm just talking to this guy in the audience, and he tells me that he's a musical instructor at a school. So I was like, all right, you're a musical instructor. Can you sing? Let me hear you sing a song. So this is what happened at the last episode of Michael Jr.'s Break Time. Check it. So you're a musical director. Cool.
Yes, sir.
All right, so let me get a couple bars of like Amazing Grace. Can you do the first part of that? Go ahead.
Amazing grace, how sweet the sound that saved a wretch like me.
Wow. That bro could sing. You know what I'm saying? All right. Now, once you give me the version, is if your uncle just got out of jail, you got shot in the back when you was a kid. I'm just saying, let me see the hood version real quick, if you know which version I'm talking about. Just see if that exists. Let me see what you got.
Amazing grace, how sweet the sound that saved a wretch like me. I was lost, but now, right now I'm found. Was blind, but now I see.
Okay, here's what I want you to catch. The first time I asked him to sing, he knew what he was doing. The second time, he knew why he was doing it. When you know your why, your what becomes more impactful because you're walking towards or in your purpose.
So I play this clip because we give so much of ourselves to this profession. And if you're doing it just to do it and you're not finding meaning in what you're doing, it's probably because you're not walking in or towards your true purpose. And there's always time to change what you're doing in life. It's important, it's critical that if your why is not consistent with what you do, it's going to make your job hard and you're probably going to burn out. And look, even if you're walking in and towards your purpose, there's times this job can burn you out a little. But can you imagine going to work every day and knowing that what you're doing is not consistent with your why or purpose? And I say that because we're going to talk about big data, and it's a lot of work. There's no shortcuts. There's no shortcuts. Doing this is very hard. It takes a lot of time, but it will prepare you for trial in a way that you probably haven't ever been prepared for before. And so, what I would suggest is if one thing you can take away from this presentation today is to go and self-reflect this weekend as to what your why is. And then ask yourself if what you're doing is walking in or towards your why, to your purpose. And if it's not, ask yourself, how can I change? What can I do to change this? And I hope that when you do that, you will be in a position where you will feel that your job has more meaning moving forward. And so let's go to the next slide. So one of the things that I was told as a young lawyer is, well, you never know what a jury may do, and you go to these mediations, like you should settle because the risk of trial, the risk of trial, the risk of trial. I hear this all the time. And many years ago, I mean, over a decade ago, I started to think to myself, I'm like, why is it that we think that going in front of a jury, it's so unpredictable? When in fact, we all know that humans are very predictable. I mean, we've lived in the age of data. We've lived in the age where the most valuable commodity in the world is data. Why is it so valuable? Because they understand if they have your information, they can get you to buy stuff. They can get you to consume more because they'll send you information that they know with your personality will drive you to act. And so we figured out that is no less true in consumer goods as it is in a jury trial. And essentially what you do have in a trial is a product. And so that's what you're selling. You're selling your case as a product, and your jury is your focus group, and you want to know if they're going to buy it or not. So we reject the notion that you don't know what a jury is going to do because we actually do know. And I've done a whole bunch of countless trials where we've predicted the outcome. And I've literally worked on either my cases or cases I've consulted on, probably $3-4 billion, and John and Alicia Campbell have probably done another 4 or 5 billion, where we've predicted the outcomes. They're just predictable outcomes. So we actually can know what a jury's going to do, at least what they most likely will do. So what is big data? Well, big data is just a virtual focus group where a standard focus group that I do live is 10, I try to do 10 people at a time. And we're going to present information and we're going to see how they respond. And we're going to take notes, we're going to create memos, and we're going to have all that access. A big data focus group is just one that we do online. And the difference is instead of 10, we can do hundreds of people. And the reason that's very important because the more people you have, the more you'll end up seeing clusters of information. And so, this kind of gives us these are just plots that we have within the data reports that show us the income range of the jurors that we are testing, the jurors' age. We get into education, male, female, non-binary. There's a whole bunch of different matrix that we capture. A standard data report is about 60 to 70 pages long with information. It's a very powerful tool. So we break down the, ethnicity, education, and so we want to know, because look, I just did a trial a few weeks ago in Provo, Utah. It doesn't take a rocket scientist to figure out that we're going to have a high percentage of jurors that are white. In Provo, we're going to have a high percentage of folks that are very religious. And those are things you need to know and be aware of. So when you're getting your voir dire and your case put together, you need to make sure that you're in line with the way the folks that are in the community are going to feel. Now, the reality, though, is that what we've learned is, and this is where the big myth forever, they've also been, well, in this venue, there's not big verdicts. In this venue, there's not big verdicts. In this venue, there's always big verdicts. In this venue, it's actually not true. There's no truth to it because it actually depends on the cases. And, if you present the case the correct way, jurors are willing to give the just verdict, right? And so it may be big. It may be, it depends on what people say is big. That's the other thing. What people think is a big verdict is very different from lawyer to lawyer. I go into some communities and they think that $2 million is a lot of money. And guess what? You don't see any verdicts above $2 million because the entire plaintiff bar thinks 2 million is a lot of money. Well, I go into those same exact venues and I don't know what everybody thinks, nor do I care. And I just use my data and I'm like, well, this is what I think the case is worth. And then I go do the trial. And of course, the case comes back consistent with the data. And I've been in some of the poorest counties in America doing this, counties that have never seen big verdicts. And so we know that that's a fallacy, and we'll talk a little bit more about that. But very interesting information that we capture during the big data studies. And then why use big data, right? What's the point? Well, imagine if there's an alien that comes down to Earth, and this alien doesn't know anything about our statistical odds of anything. And this alien says, well, I want to flip this coin. I want to know what the odds are that this coin that has a head on one side and a tail on the other, what are the odds that it's going to land on heads? And so the alien flips the coin 10 times, and 2 out of 10 times the alien gets a head. Uh, the alien then, if he were to leave and go back to the spaceship and leave, and it reports back that says, hey, listen, we found something out very important. If you flip this coin, you're only going to get heads 20% of the time. So always bet on tails. That alien would be foolish because what happened is the alien just simply didn't have enough data. Because we know if we go ahead and flip that coin 50 times, maybe you get heads now 33 out of 50 times. So instead of 20%, it looks like it's 66%. And if we say, well, let's flip it 100 times, maybe you get 62 out of 100. But what we know for a fact is that the more we flip the coin, and we get up to, say, 350 flips, you're going to get closer and closer to the truth of 50%. That's what big data is. Big data is we're doing tons of people, and the goal is to get to see what the most likely result is for different categories of jurors. I call them our worst day jurors, our 50th percentile juror, our best jurors, which I put at 75%, and then our average juror, averaging them all together. What does that look like? But and the reason why we do that is because right here you have we want a whole bunch of flips so that we get more to the truth of how the average juror is going to look at this. And then of course, the better you are at jury selection, maybe you can push it closer to the 75th percentile type of outcome, which we call best day outcomes. All right. So how do you determine the value of a case? Right? Historically, what we know is that most attorneys guess, right? And the attorneys that spend a lot of time go and look and they do verdict research. The problem is every single case is different. So just because you have a case that involves a L5S1 fusion doesn't mean that those two cases are worth the same amount of money, even close, because you could have somebody that had a L5S1 fusion like I've had, and I fully recovered. And I'm out there doing all kinds of activities again. I have another colleague in my office who had a fusion surgery, and his outcome was terrible because they paralyzed his arm. Well, same surgery, well, different surgery, but same idea, right? Outcome's totally different. I'm perfectly fine. He can't move his arm. Well, what's the value if those were cases? What's the value? They wouldn't be anywhere near the same. And so doing jury research that way is invalid. It is of no value. And attorneys that do that are likely undervaluing the case. And what we know is that over the last 5 years, jurors value pain and suffering much greater than they have in the past. And likely that is because attorneys are getting better, plaintiff bar is getting better at being able to explain the case in a manner that jurors understand why the value should be what it is. So the one thing you don't want to do is you don't want to guess, and so what we see all the time is attorneys sit there and they go, well, I think this looks like a $5 million case, or maybe it's a $15 million case. What if I said 15? Uh-oh. What if it's not enough? Oh my gosh, right? You fall right off the cliff. And what we've learned is there is a right and wrong answer for what you should tell the jury the case is worth on both the plaintiff and the defense side. The defense usually gets it wrong because they're just guessing. They have absolutely nothing. And even if they run a focus group, they still don't understand how to determine value correctly doing the live focus groups. So what kind of answers can I get? Well, we can get there. We call them empirical questions, and an empirical question is just a question that has a right and wrong answer, right? So if somebody were to ask me, what do you like more, apple pie or cherry pie? And I were to say, I like apple pie more, that is not an empirical question, right? Because the next person that comes up isn't necessarily going to say, I like apple pie more than cherry pie. Doesn't mean that the apple pie is actually even better than the cherry pie. It's just my opinion. But what would be an empirical question is, hey, if I was going to open a restaurant and I was going to sell one type of pie, should I sell apple pie or cherry pie if I want to sell the most? So then we could go and ask 350 people, hey, here's two pies. Which one do you like more? And if 78% of the people say, I like the apple pie more than the cherry pie, then you would want to make the decision to sell the apple pie, not the cherry pie, because you know that you've got 3 out of 4 people would rather have the apple pie. And so, for purposes of making the right decision to sell which type of pie, that's empirical. So whether or not I personally like it or not is not empirical, but whether or not the average person, which one should I sell because more people like it, that is empirical. Here's some other empirical questions. Should I dismiss the individual defendant? How much fault will my client receive? How much should I ask for in damages? If the court excludes my OSIs, which are other similar incidents, will I still win my case? Is my client credible? Should I begin with the conduct of the defendant or the severity of my client's injury? Does the fact my client needs an interpreter alter how the jurors see her? What perspective angle of my animation is most effective? Should I waive the medical bills or some other economic claim? Those are all empirical questions, and there's right and wrong answers. So here's an example of a case that I did with my partner, Will Sykes and Jordan Logan. This is the case of Espana versus Republic Services. And this too was a right-hand turn case at a crosswalk where our little girl was walking from home from school and was run over and killed. So in that case, one of the things that we had to deal with is the day before my client was killed, there was a birthday party for her aunt at her home. And our client was telling everybody that when I grow up, I'm going to buy my mom a house. I'm going to get my mom a house. And I just thought it was such a great story. And I'm like, man, as a storyteller, I really want to tell this. But the question is, should I tell that story? Should that be an element of damages that we ask the jury to compensate for? Well, that's an empirical question. I can actually figure out, should I or should I not do that? And so what we did is we ran a data study and we tested 3 different numbers that we would tell the jury that the case was worth. And then whichever one tested best, and we did it all with this whole idea of economic loss of probable economic support that the mom had with the daughter. And what we decided was, okay, we'll take the best one that tested out of the 3, and then we'll remove the economic and see if that moves the needle at all. And here's what we found out. Should we ask for the house? Well, the first numbers we tested were 25 million, and the 5 million, Jasmine was a little girl who died. This was for her pre-death pain and suffering, and then the mom's obviously wrongful death claim. And the low with eco means this was the lowest amount we tested with the asking for the economic loss of probable support or asking for the house. The win rate here was 69%. Now, from our standpoint, we want to see 70% and up. If you get to 72% and up as a plaintiff lawyer, you're going to win the case. The defendant will lose the case. And so that's what happens. So the second number we tested, the mid number was 50, 10, and 40, also with the house. And the third we tested was high, the high amount was 75 with the economics. Now, look at the win rates, 69, 72, 70. So there's essentially anywhere from 2 to 3% is within a margin of error on the win rate here. And so we're not looking at this saying, oh, there's no difference between the win rate on the 69 and the 70. That to me is about the same thing. Maybe this is about starting to see a little bit difference between the low and the medium, but then when you go to the high, you get a little dip down. So So what we end up doing, we said, hey, let us test the high without asking for the house. And what does that do to the win rate? Now we've got statistical significance because we bump up 10%. It's a 7% gain, but that's a 10% statistical gain. And so that becomes statistically significant. And we now know, without even looking at the damage model yet, we know that just on the win rate, that this is the right thing to do. This is the right move, is to tell the jury the case, they should return a verdict of 75 million and do not ask for the loss of probable support. It becomes a no-brainer. So then let's look at this. So this is what's really fascinating, is that if an attorney doesn't know the right number to tell the jury the case is worth, it can impact the case. Now, what I want to, and we're going to talk about this at length, and you all are going to get a paper, the most significant jury research that's come out in many years out of Cornell. It just got published, and we're attaching this as part of the material you're going to get that talks about, and we're going to talk about at the end here, the idea of anchoring. And what we've learned is that there is no question that anchoring does not work, meaning that if the evidence doesn't support the number that you're telling the jury the case is worth, it doesn't make any difference at all. That has to be connected with the severity of the injury, and if it's not, then it doesn't matter. Now, that being said, it doesn't mean that you couldn't tell the jury the wrong number because you just didn't know the value of your case. That's very different. And you're going to see that here. So this is not an anchoring issue. This is just an attorney who went and said, I'm going to tell the jury $25 million. And the lower quartile, this is your bad jurors, right? This is if you're the plaintiff lawyer. If you're the defense jurors, this would be your great jurors, would value this case at 3.56 million. That's, and if you imagine if you have 100 jurors, that would be at number 25, whatever the number 25th juror from lowest to high gave as a verdict. And in this particular case, it would have been 3.56. The median simply means 50%, and the upper quartile 75%. So, and then the mean is the average. And so what I usually do is, and when I'm trying to get cases settled, I want to settle between the median and the mean. Those are the two numbers. I don't try to, when I'm trying to resolve a case, I don't tell the defense, you should pay me my best day. That's not what settlements are. Settlements should be what a fair value would be on average if we try this case 100 times. And so that's kind of what the average is, the mean and the median. So if in this particular case, if I would have suggested 25 million, and that would have been what the only data I had, I would have thought that a good number would be somewhere between probably 10 and 13 million to settle the case. But we wouldn't do that because when I tested 50 million, it all of a sudden jumps up immensely. And so now all of a sudden, even my worst day goes up 500,000. My 50th percentile goes up 3.1 million. My best jurors all of a sudden are up $22 million, and the average has jumped about 9 million. And then when we go to the highest ask here, it's 75 million. We see that the average is 29.58. And look at it's basically a $17 million difference just because we didn't know the true value of the case. It's pretty shocking. And there's a lot of attorneys that make this mistake, and it's important that you as a trial lawyer, no matter what side you're on, you understand the true value of the case, and you can only figure out the true value from doing data, and doing it honestly. And to do it honestly, you have to write a really robust defense statement, and you have to write a robust plaintiff statement. And if you do those two things and you get it right, you're on to something. And look, something that I've been really pushing for, and unfortunately I haven't got any of the carriers to agree yet, but I think we will, is to have the defense lawyer, we get with the mediator, the defense lawyer writes the defense statement, I write the plaintiff statement, the data gets run, and we all get to look at it and see what it says. And then you can make a decision from there. If you want to roll the dice, go roll the dice. It's all right. You may not have a job when it's done if you got it, if in this particular case you saw that the average value was 29 million with this one. Now we're going to see what happens when you get rid of the house. You get rid of the house, 75 million all of a sudden bumps to 38. So you're talking about an $8.5 million difference on average by not asking for the loss of probable support. And your win rate's 77% instead of 70%. And my best day goes from 50 to 65 million. And my 50th percentile goes from 20 to 30. And now my worst day, 11 million bucks. It is a no-brainer on what to do in this case. But imagine that the defense has the opportunity to sell this case for 32 million bucks. And they choose not to, right? And then they go and get hit for, somewhere around 38 million bucks. Well, somebody just made a $6 million mistake and they would have known it. Like we know we're probably making a mistake because on average, this case is going to result in a $38 million verdict. No sense in making that mistake. None. But it gets made all the time. And it's usually because the defense just doesn't know. They have no idea what the case is actually worth. They're just guessing. And all the methods that they've used in the past are just they're not effective anymore. So here's something else that we get from our data. We get to understand what's driving the decision making of the jurors. So for example, well, let me go to previous slide. All right. Within the data, you will also see that you can see what's actually driving the behavior of the jurors. And meaning it could be that for what's driving you in our data studies, you find out what's driving the plaintiff jurors to act favorable for the plaintiff. You also find out what's driving the defense jurors to act favorable to the defense. You absolutely want to know that information because if you're on the plaintiff side and you understand, oh, what's driving the defense jurors is this fact. Well, maybe you need to lean into that bad fact and own it and disarm it. Maybe you need to try to file a motion eliminating to keep out that really bad evidence. And if you can't, maybe you need to settle the case because sometimes there's facts that just I was in Denver presenting to a group yesterday, and one of the attendees came up to me and asked me a question about a fact of his case. I'm like, ooh, that's a tough fact. I don't know. I don't know. I don't know how I deal with that. I would test it though, because I'd want to know if it's a case killer, you know? Because one of the things that good defense lawyers do is they find inconsistencies with the plaintiff's medical history and their treatment, and being a human being, it's not hard to forget doctors' names that you saw or how you felt on a visit or what have you. And so, you got to be aware of that stuff. And so, but you really want to know what's driving understand what's driving their behavior. You can tell a story that is, you can have a story that makes a lot more sense to tell the jury. And if you need to lean into something, you lean into it. If you need to explain it, you can explain it. But if you don't know that, man, you know what the defense jurors are latching onto? It's this. Or if you're the defense lawyer and you're like, oh my gosh, I didn't realize that the defense that I'm making is actually driving the verdict up. I see that all the time. We have our data and we know that if the defense makes a certain argument to defend the case, that it will actually increase our win rate and the verdict. So we don't even try to exclude their experts. We want them to go in and make these arguments, and they feel emboldened. And what they don't realize is they're walking into a hornet's nest. But you can only understand that, because a lot of times you have these experts that are just they're low-hanging fruit. You can get them for, you can strike them under Daubert or Fry, or in Nevada we call it Hallmark, whatever your standard is. You get these experts struck if you want, but should you? That's an empirical question. Should you strike the defense expert and not have them testify, or should you let them come to trial and say the stupid stuff they're going to say? That's kind of like an amazing thing. And I'll tell you, with the Espana trial, we saw the numbers there, that it was a 38 $37.99 million verdict. That actual verdict was 38.6 million. So pretty accurate as far as value went. And it was important for us to know that too, because during trial they offered us before trial the top offer I think was 500,000 or 1 million. It was quite low. And by the time I rested my case, they had offered 15 million. Now imagine a situation where I didn't have the data and they're offering 15 million. I take that all day long. But what I knew was my best day, my worst day was 11 million because I knew from the data, oh, if I don't have a good jury, I'm still going to get 11 million. So I'm all right. That's not much risk. But if I hit it, I could get up to 65 and my average day is 38. We're going to say no to the 15. And we did. And it allowed my client to recover a heck of a lot more money because the verdict came in, like I said, at 38.6. So here, let's talk about anchoring bias. I just did a trial in Provo, and I became good friends with a very good attorney out of Cleveland that was on the defense side. His name's Jim Gordon, and Jim's a great guy and a very skilled lawyer. And he made an argument to the judge that before trial, when we're talking about voir dire, that he did not want me to be able to talk about numbers in voir dire with the jury to see if there was a bias. Is there an amount that you couldn't consider before even hearing any evidence? And he argued that, oh, well, I read a book called Think Fast, Think Slow, right? And in there it talks about anchoring, and he used the example of Gandhi's age. And the difference is that there's no context. There's no context. And so in the article that we're providing you, it's a fascinating look at the amount of juries and mock jurors that were studied is incredible because they want to see what happens and meaning if I go and suggest $1 billion and just I say $1 billion, does that mean that somehow, some way I'm going to get more money than if I were to have suggested 75 million because that actually is the right number to ask for versus $1 billion? Well, we test it, we've looked at it. Like, how does it work? Like, do juries actually follow and believe in anchoring? Does it really work? And the answer is no, not at all. It actually doesn't work at all. And it's because if you've got a case that involves a broken foot, and that's it. I mean, it's a fracture. There's no surgery. It heals on its own. The person's walking normal in 6 weeks, and you go and tell a jury that case is worth $10 million because of a broken foot. You're not going to get $10 million from anybody. And we know it because the data tells us that. The study tells us this. It also is one of those things that I don't even know that we needed this huge study to realize how ridiculous the argument being made that anchoring works. Because if that were true, then every time a plaintiff lawyer said a big number, they'd win. They'd win big. I see attorneys that have crappy cases suggest big numbers and they get defensed all the time. I see attorneys that have maybe good liability, but not anything on the damage. I just watched a very, very good lawyer. He asked for, I think it was $100 million he was telling the jury. And the jury gave him like 3. Not because he's not a great lawyer, it's because the injuries didn't match the damage ask. It was that simple. And so if your case does not support the number, you're never going to get the number. And in fact, we know that in 14% of the time, they're going to reject your high anchors. They're going to reject them, meaning that they may end up giving you 0. And what we see is the jury behavior is they're actually, jurors are way smarter than people give them credit for. So what we know is that it doesn't really matter what we tell them the case is worth. They're going to go back there and they're going to deliberate and they're going to come up with a number. And ask yourself, how many trials have you been in ever where the jury gave exactly what the plaintiff asked for. I mean, the defense gets it all the time when they suggest zero and they win. I mean, that's I guess predicting it, getting it just right. But I mean, can't go lower than zero. Although I'm sure some of those cases where they get zero verdicts, if the defense could get money from the plaintiff, the jury might give it. But it doesn't actually make it's just if anybody is out there making the argument, um, use the article that we have and just shut it down because it's just there is no science behind the argument. There is no proof behind it. It's just conjecture. And when I was in trial a few weeks ago, the article had not come out yet. I knew that it was in the works. And I was excited to see it because I'm a nerd and I read all about everything that's going on at every jury research place I can because I want to know what's going on out there. And so when Cornell finally released this paper, I was so excited because it was such a robust study. And so, yeah, I would suggest everybody read it, understand it on both sides because it's an improper argument to make if you're the defense. You should want to know where jurors sit when it comes to damages, so you can make intelligent use of your peremptories. And look, there may even be a cause challenge there if a prospective juror says, "I got to give money. I don't care what the evidence is." And so, talking about money in jury selection is good for both sides. And so, I would encourage everybody to really read and understand what the reality of jury behavior is. So here's something else that's really cool that we get out of our data studies is we get what we call word clouds. And in the last trial I just did, and then this case I did in Provo, Utah, it was called Matson versus Beacon, Allied Beacon. It was a roofing company. The defense jurors is in red, the plaintiff jurors are in blue. This is how they're describing our client who was killed. The defense was saying young, they both said young. But then look, instead of kind, child, victim, it goes careless, unlucky, kind still there, tragic, distracted, energetic, reckless, immature, carefree, impatient. These are all the defense words. Impulsive. And then we come to the plaintiff side and you get kind, young, victim, sweet, caring, careless, helpful, hurt, dead, gone, loving kid. And the bigger the words, the more common they were to be used by the jurors. But you can see that it's a very different word cloud, the way the defense jurors are describing the child versus the way the plaintiff jurors were. So you need to know that. You need to understand how how bad jurors are going to look at your client, whether you're plaintiff or defendant. And I say bad, I mean in this particular case, because this organization has both plaintiff and defense, it could be either. You just depending on where you're sitting. But these are very helpful when you're in prepping for trial and in trial. This was the defendant driver, a guy named Rusty Cope, and the defense jurors were describing him as trained, qualified, unlucky. He competent, hardworking, distraught. You do have some careless, arrogant, reckless. So you do have some bad words even on the defense side, but compared to the plaintiff's jurors, irresponsible, dangerous, careless, liar, dishonest, arrogant, guilty. Very different the way that these folks are viewing the witnesses. And then the corporation Beacon is described by the defense jurors as defensive, business, employer, corporate, safety, thorough, capable, trained. I mean, good words if you're looking, as far as the defense goes. And then the plaintiff jurors, though, describe it as careless, greedy, uncaring, unsafe, corporate, reckless, company, dangerous, responsible. And then, you have a bunch of little other smaller words. But obviously very different in the way that the parties are viewed between plaintiff and defense jurors. So here's the interesting thing. We were in Provo, Utah, and we had an 80, the data, this was a case that was tried and lost the first time about 4 years ago. And our referring attorney, awesome lawyer, great guy out of the Provo area, a guy named Blake Johnson of Johnson Livingston, was able to get a new trial and brought us in for the second one. And when we ran the data the second time, we had an 85% win rate. We had two kids that were his friends that were with him, and they saw Michael get run over and killed. So they had negligent infliction of emotional distress claims. That win rate was 65% on that. The expected value best day was 78 and a half. And the fault to Michael, we did a couple different studies. We got it down all the way to 7 from 24, based upon some of the stuff that we changed up for the trial. But what's not shown here is that our 50th percentile juror had 0%, which means if I got a good jury, I knew I could get the comparative fault to 0. And we got a really good jury. And in fact, that's what happened is we got the 0. Our verdict was 81. So, I mean, really close to the 78.5 predicted. We had our best day, right? That doesn't happen every time, but the better you get at understanding the data, implementing the data, the more often you can, get to your best day. And, it takes some help from the defense. We had a defense lawyer in this particular case that was, there was two different defense lawyers. The one from Cleveland was very wise, and he made a lot less errors during the trial than the other attorney, who just wanted the defense verdict again so bad that they were taking some really untenable positions that just candidly, I think, fired the jury up a little bit, which helped get the verdict over the best day. All right, so let me stop there and see the Q&A. Where do I have the Q&A? There we go, more. All right. So we got a question from Jack Russo. Do you share your data to the mediator? Absolutely. We educate. We want to educate we want to educate the mediator ahead of time. The more educated you have, the more educated your mediator is, the more likely it is that you're going to get them to understand that you're not moving. And you have to be true to your data. You don't want to be in a situation where you run the data and then you go mediate and you take 10% or 50% of what the data says your average day is. If they're not going to give you a fair number, then just go to trial and go take it from them, because you're going to get it. And I got to tell you, I've consulted with a whole lot of attorneys around the country, and some of them are amazing, and some of them you watch in trial and you're like, wow, that is not impressive. But what I've seen time and time again is it doesn't matter how talented the lawyer is, if they stick to what the data is telling them and tell that story, they win. And they win just as predictable as I do. And that's what's so fascinating to me. And so I would say that definitely share it with mediator. As far as the opposing counsel, I've developed some really nice relationships with some of the top defense attorneys in the country, and they've seen me go to trial over and over and over again and get my verdicts that the data shows. And so I do show my data to them, and I'll show them what it's going to take to get the case settled. And they know I don't vary in what I tell them where I'm going to settle the cases. I'm going to settle between the median and the mean. They know this. I don't, look, that's my job, is to get a fair result. That's a fair result. And so they know that, and I go, look, get between these two numbers and we can call it a day. And so, but a lot of defense lawyers still, for whatever reason, oftentimes just simply do not, they don't believe it. They think that I've somehow manipulated this. I'm like, dude, I spent $35,000 on this study. You think I'm manipulating it so I can feel good? Look at my track record. Do you think I'm manipulating it? Do I keep just getting it right no matter what? I did a trial in the most poor county in America, in New Mexico. It's north central New Mexico. You've not seen poverty like this. I promise. They didn't even have drinkable water there. It was really bad. And that jury even though it was the poorest county, I believe, in the country, came back with a $485 million verdict. Didn't matter because the evidence warranted it. It was a child who'd been raped in foster care. And they were like, no, that's not okay. We're going to take care of this little girl. And they did. And they punished the defendants as they should have. So, Jack, that's how I'd answer that. Heather Atkinson, what about damages for emotional or intangible injuries such as discrimination, false light, and malicious or vexatious abuse? How do you value the same way? Same way. We do that all the time. We do defamation cases on the regular. We do employment cases on the regular. And the great thing is if you have those cases and you want an example when you're working with John and Alicia, and understand everybody, just so everybody is clear, I have zero interest. I don't make any money from any data study that's run. I just am such a believer in it. And I wrote the book with John and Alicia because I was the earliest adapter of this technology in using it in litigation. But that's how this how it works. I don't get any money from it, but I'm telling you, I believe in it. And so what's great is you work with them and then they will, and here's the other thing, if you're worried about the cost, if they like your case enough, they'll do contingency. And the best thing in the world on a contingency with John and Alicia, we hire them on contingency quite a bit. Because I want to be able to run a lot of studies. And more importantly, I love having them be my jury consultants. And so if you get them on a contingency, oftentimes they will come in and be a jury consultant for you, and it is awesome because we have software. So I'm going to blow your mind right now, Heather. If you get a jury questionnaire and or if you know all your questions you're going to ask in jury selection, we can ask those questions when we run the study, and then we can see exactly who your best jurors are and which questions are predictive. And then when you go, we have software, and when you get your questionnaire and or when you get you ask your actual questions and you're typing them in for each of your jurors, our software can score that for you, and then you know who your best jurors are. And the defense has no idea. They've got like gut instincts that are never right and stuff like that. We're just using data to predict each of the. You still got a little bit of the experience that you have as a trial attorney, be like, yeah, they're saying the right thing, but they don't look right, But I got to tell you, a lot of times that may be more you, because if the data is saying they're good, they're probably good. So all right, so Bruce Cochran, let's see. I'm sitting here amazed. Been a trial lawyer for 47 years, 25 as a plaintiff and 22 as a defendant. Done dozens of focus groups and mock trials and was totally unaware of this. I guess better late than never. Uh, well, good. I'm glad that you're excited about this. Yeah, the book is. You can go to juryball.com and buy the book. It's a great book because not only does it tell you what data is and how it works, but my portion of the book was how do you actually implement that into your case? How do you implement the data into your case? And we give you all the techniques to do so. What would a backfire be with regards to the anchoring? Well, the backfiring would be that they actually take your number and then punish you with it, right? And then use it against you. We don't actually see the juries doing that. If they think the case is a zero case, they're going to give you zero, right? That's just the way it is. So now I will tell you there was a case that we consulted on where this attorney, we had done all the data. We'd done work days with this guy. It was all dialed in. The case was dialed in. And he felt like trial was going really well. And I was actually in a trial in Portland, Oregon at the time. We were waiting for our jury to return the verdict, and he was about to go do closings. And he's calling us. And he's like, I'm going to ask for double what we tested in the data. I'm like, oh, please don't do that. Like, we don't have any idea what that will do to your case. And you're already on the line of whether you're going to win or lose. So just stick with what we've studied. Do not do this. But he was very confident that the jury loved him. And so he went and told the jury a number that we didn't ever test. And the jury came back with a defense verdict. And I'm like, well, okay, there you are, Probably would have been a different outcome if you would have just trusted the data. So, um, Heather Atkinson, Sean, how are you paid? In advance or on a contingency? Well, the only way that I get paid is if I do two things. I either will consult or be co-counsel. And so on a consulting basis, and all this is, I have limited bandwidth, but if I really like your case, what I can do is I can go ahead and um, consult. And with that, you come to Vegas and we do work days and we put your whole case together. And you end up getting an opening statement, you get your order of proof, you get your voir dire questions. We literally hand you your whole case on a silver platter. You just got to go execute. And it's a lot of fun because a lot of attorneys want to get those big verdicts and because we want it so bad, right? It's our ego. And I get it. And it's easier for me because I can consult on 5 to 6 times more cases than I can try. So in a given year, I'll personally try 3 or 4 cases, but I'll consult on 15 to 20. And so it's just a lot of fun. And then RJ Hendricks, is your firm running these online jury studies or do you use, no, so yeah, so the answer is I use John and Alicia Campbell. Um, and that's who we use every single time. In my opinion, they're the best in the business. They're the thought leaders in the industry. And most importantly, John and Alicia are both trial lawyers. They're actually in the trenches all the time. Unlike anybody else, it's a fantastic group. Uh, so um, so there you go. I think that's the last question. If anybody has any other questions, if you want to get a hold of me, you can reach me at my email is Sean, SEAN, at claggettlaw.com. And if you'd like, when you shoot me the email, I'll respond with my cell phone number and we can chat. I'm a huge believer in the need for lawyers to give back and share knowledge and not charge for it, which is why I do so many of these free CLEs. I never charge anybody to speak. And so that's kind of just what I do. So I want to thank everybody. I think we're right on time. So thank you so much. And hopefully we'll see some of you all at JuryBall Vegas.
All right, this concludes today's presentation. Thank you so much, Sean, for an excellent presentation today. And thank you so much to our audience. Have a great day, everybody.